Scott Mars of Beirne Maynard and Parsons has over 20 years of experience in litigation in energy, intellectual property, commercial, product liability, and international matters in state and federal courts, and in national and international arbitrations. Today, Scott discusses how to harness the power of arbitration to obtain successful results. Please welcome Scott Mars.
Well, thank you, Lou. Now, I know what you're all thinking right now. You're thinking, another boring speech on arbitration? I just can't stand another one. What was Ellis Mirsky thinking? Well, I think Ellis, our fearless leader of the network, is a visionary because he knows that we have lost our way, our mojo, as it relates to arbitration. And when he asked me to do a speech on arbitration, the first thing I thought of was my favorite arbitration movie, 50 Shades. And that scene where Mr. Gray explains to his new girlfriend that arbitration should not be like litigation.
I'm not exactly jumping at the opportunity to get whipped and tortured in your red room of pain.
If done right, arbitration doesn't have to feel like litigation. I promise you. I want you in the arbitration room in 15 minutes.
Now, that kind of puts it in perspective, does it not? Because really, arbitration should not be like litigation. You know, back in the 70s and the 80s, we were seduced by arbitration because we thought it was the answer to our litigation woes. But instead, it has become as expensive as litigation, with discovery that's often as expansive as litigation, arbitrators that split the baby, who are not required to follow the law, and you have no real avenue of appeal. Why would anybody want to arbitrate? And when you lose your mojo about arbitration, you start writing articles like this: Arbitration and the Godless Bloodsuckers. Well, you don't have to be like this, and you won't be, because in the next 20 minutes, we're going to learn how to actually think that arbitration is good, how to streamline the process of arbitration, and how to make it confidential. In essence, how to get and protect your mojo. Now, it's important to note that just like animals, there are no bad arbitrations, just bad owners, okay? Bad drafters of arbitration provisions. And I know what you're saying. A lot of us trial lawyers, we are stuck with arbitration provisions that others drafted. And here we are representing a client with a horrible arbitration provision. But don't forget, you can always, even after someone triggers arbitration, agree to amend or change your arbitration process. Now, why is arbitration good? It's great. It can be because it's fully customizable. Where else in the world can you pick your own judge, design your own system tailored to your particular business sector, your environment, the types of contracts you deal with day in and day out? Now, do you have clients or a board or officers in your company that want to keep lawyers at bay? My guess is yes. And how? For one, provide a stair-step system where the parties have to, principals of the parties have to negotiate first. It's amazing when a principal of a company does not particularly want the legal department to get involved in how this dispute arose to begin with, and how, if they have to negotiate, they can come to a resolution first. But if not, then you have to mediate. And if that's not successful, then you have binding arbitration. You want to pick your own judge? Of course you do. That's what arbitration's all about. Make sure that judge, that arbitrator, is your expert. They've got experience in your field, insurance, energy, whatever it may be. You can provide, they have to have a decade at least of experience in whatever your industry may be. You can even ask for a former judge, of course, if you want one. Sometimes you might not. And you can even say, we've got to pick among the following 3 specific individuals. That ought to give you quite a bit of comfort. Now, also, do you hate delays? You can eliminate them. How? Shorten the time fuse. You know, if you put that an award must be rendered within 6 months of the trigger of arbitration, guess what? If it doesn't happen, the arbitrators lose jurisdiction over your case. They only have jurisdiction because of that arbitration provision. The hey, expensive and time-consuming motions, procedural disputes, discovery battles, expert battles, sounds a little bit like litigation, doesn't it? Well, you can further streamline arbitration, and here is how. Number one, always submit before the hearing, before that preliminary hearing where you're supposed to agree on timetables, deadlines, etc. When I'm the arbitrator, whether it's CPR, ICC, or AAA, I don't even use the AAA or the tribunal's form. I use my own. I have a 2-page form. It's got all the deadlines. I expect the parties to agree before we have our first teleconference. Agree on a date. Come to me. I'll see if I can do that date for the hearing. And then we're going to back out. And I want you to agree to all the deadlines before we even have our first hearing. Because on the telecon, the last thing your client should be paying for is everyone looking at the calendars only to say, oh, we need another hearing so we can get with our clients now to see if they're even available on those dates. That's not efficiency at its best. Also, include deadlines for various things you want to happen, but do not put deadlines in your form if you're using your own if you don't want that particular thing to happen, such as whether it's dispositive motions or experts. Don't provide deadlines, obviously, if you don't want experts in your case. Streamline discovery. You know, 50% of all costs for any litigation is discovery. We all know that, often more. So you can limit discovery or prohibit it altogether or simply accelerate it. And remember, the AAA rules changed significantly in 2013. Now, an arbitrator may order docs that a party intends to rely on. That's pretty narrow, isn't it? Now, he or she has discretion to then order more documents that are relevant and material. You know how many people are not aware of the new changes to the arbitration rules? Some arbitrators as well. So when your counsel or when you get that discovery in that arbitration, look at the rules and determine, you know what? This doesn't even fall within the narrow guidelines of even the AAA rules. It's not like many state courts where the scope of discovery is information that may be calculated to lead to the discovery of admissible evidence. You don't want that, and the new rules in most tribunals are much more narrow when it comes to discovery. And I've had a significant non-figure arbitration where I was an advocate, the plaintiff, and used the IBA model where the parties only had to produce what they intended to rely on. Obviously, they're not going to rely on those bad documents they have back at the home court. But indeed, if you incorporate the IBA rules, that is all. That's kind of the European system. Whatever I'm going to use, I produce, and I'm producing nothing else. All right, ESI, electronic discovery. Absolutely, this is very expensive, as everyone knows, but you can limit the scope. You can say we can only get discovery from 2 custodians, which can significantly reduce the cost, or you can prohibit electronic discovery outright. Now, depositions is a very big issue in arbitration. Many believe you get as many depos as you need to, just like in litigation. But you need to know the rules as it relates to depositions in the various tribunals. And it's quite interesting, actually, because, for example, most cases I deal with are complex commercial disputes, perhaps under AAA rules, and they now provide you get depots in an exceptional case and for good cause. If you don't think the plaintiff should be able to depose your CEO and every board member you have, perhaps you ought to look at the rules and learn them and realize maybe that's not an exceptional case. These are the tools, the rules, to go back to the tribunal and the panel to say, wait a minute, this is arbitration. It's a new day in arbitration. It's narrow. You can't get discovery like you can in trial. This is what we all agreed to, arbitration for expediency. And don't forget, you can say that the dispute will be governed by the AAA rules, but you can also carve out certain things. Discovery will be governed by the JAMS rules. You can cut and paste like that if you choose in your own arbitration provision. Why do I say that? Well, If you incorporate the JAMS rules, they specifically provide you only get one deposition. That's interesting. All right. So, also, you can provide that any discovery, and I highly recommend this, I do it in every arbitration, either as an arbitrator or an advocate, the panel chair can decide discovery disputes. You don't need 3 arbitrators to decide every single dispute. That's triple the cost. Also, you can provide, and this is what I do in every arbitration where I'm an arbitrator. Look, parties, if you have a dispute, don't file motions. I don't want them. Your response and your reply, your reply, you know lawyers. Okay, so I want you to send me 2-page max letter. That's it. Tell me what the dispute is, what you need, why you need it. That's it. It's amazing how lawyers can become very concise when they have to do it in letter form. And it hedges against this rule, the Northcott-Parkinson's law. Work expands to fill the attorney time needed or available to complete it. It's like my teenage daughters, where money expands to fill the amount of money Daddy says he has. All right, so written submissions, always provide limitations on that in your arbitration provision. That can get very expensive. Dispositive motions, this has also changed significantly, but it's nice to agree within the provisions that arbitrators can rule on dispositive motions such as motions for summary judgment. Why? Because we all know arbitrators are reluctant to give you dispositive relief prior to your hearing, because they know, especially if the Federal Arbitration Act applies, that is one of the 2 reasons why most arbitrations are overturned, because an arbitrator has failed to allow a party to put on their evidence. And arbitrators are worried about not allowing a party to present their evidence at a hearing. But you know, times are changing. I think arbitrators are becoming more educated about the necessity for pretrial relief, pre-hearing relief, and the rules are changing as well. The AAA was founded in this very city in 1926, and for the first time in 2013, it has a rule about motions for summary judgment. Well, that's nice, and you can go to the arbitrators and say, I know you don't want to do this, but don't worry, now there is a specific rule, and you really should rule on our motions for summary judgment or other motions to dismiss or other dispositive relief. Battle of the experts. Well, I got to tell you, most clients tell me this is the frontier where they still feel like they cannot control costs because they don't usually retain the experts, they don't communicate with the experts, but they get the bill and they can't believe it. In arbitration, shouldn't your arbitrator, if you have the right arbitration provision, shouldn't they be the expert in that field? They should be. You can provide that there won't be experts, or you can provide that a neutral fact finder can be retained by that arbitrator or jointly by the parties to advise the arbitrator on those issues. Or, and I've done this before, you can have expert reports only, no testimony. Most arbitrators are lawyers, they understand the reports and perhaps the weaknesses, especially where there are a battle of reports. Or you can provide only that the arbitrator is the only one who questions the experts, and I love that because I can ask what I want to ask. I don't have to listen to it all over again when I've already seen it in the report. Evidence at the hearing, witnesses. You can limit the number of witnesses per side. You can provide, and I really like this one, no direct examination. I did this in a very significant case very recently. The direct testimony is given by statements to the panel first, so they know what they're going to say. So straight up, you go right in to cross-examination only. It's very effective, but your clients better darn well be prepared, right? Your witnesses, especially if you're the plaintiff. I was a plaintiff, right up. My CEO's on the stand, and guess what? I couldn't direct them because we agreed to this, cross-examination first, so they have to be prepared. Pre-mark your exhibits, pre-admit your exhibits. This shows that you're prepared, and it makes everything smooth in the hearing, and it becomes much more efficient. Now, documents. I love it when I'm the arbitrator and the parties say, you know what, we've had the hearing now, we know we gave you 10 notebooks of thousands of exhibits, we're going to take them back, and everyone knows you only use like 10% of your exhibits anyway. It's effective on the last day to say, ladies and gentlemen, I'm going to give you this one notebook. This is all you need. Everything you need to rule in this case is in this notebook. It's highlighted. This is it. You don't want to take all these exhibits home with you. We'll take them for you. They love that. You're efficient. You're concise. Now, chrono boards are so important because they do give a good roadmap, just like your hot doc notebook and draft award. I got to tell you, this is significant because instead of post-hearing briefs in every arbitration I do as an arbitrator, I tell the parties, I don't want a typical post-hearing brief. You know what I want? Give me the opinion. If you win hands down on all issues, the opinion from this panel that you would expect to see. Why? Because then they have to be persuasive. They have to say, I rule according to the evidence. Here's the evidence, and here is why. And we get that in Word. We can cut and paste if we agree with a certain position. And it's much different than just a post-hearing brief where you see the arguments all over again. And it's very significant if you're the party trying to persuade that arbitrator, here is how you rule. Now, most clients want arbitration because arbitration is confidential, right? Mostly incorrect. Why is that? I don't know how many clients that I've explained this to, and they cannot believe it. They thought arbitration by its nature was confidential. That's why they agreed to it. Wrong again. Why? Look at the rules. The rules across the board in almost all tribunals provide that the arbitrator and the tribunal has to keep it confidential, but not the parties. This is significant. Only the CPR rules require that the parties themselves keep the proceedings and the documents filed and the testimony given confidential. So, how can you make sure it's confidential? Include your confidentiality provision always, unless you're under the CPR rules, and I still would do it, such as, and all the tribunals typically in their books will have sample clauses for confidentiality, that you'll maintain the nature and the award, including the hearing, all the testimony documents, confidential. This is significant. You do not want your client to call you and ask why it is that the documents filed in their confidential case are on the World Wide Web. Okay, most important tip of the day, and I love this one. Why? Because most people are somewhat surprised by this. How to guard against inadvertently giving the arbitrators the power to award millions of dollars against your client in attorney's fees. So question, this provision, the one that says the parties are responsible for their own attorney's fees. Now, that protects you, right? Because the parties have to pay for their own attorney's fees. Absolutely false. Now, why is that? And I've seen this. This happens because if you're incorporating the AAA commercial rules and both parties request attorney's fees, regardless of that provision or any other type of provision like that, guess what? You're giving the panel the power to award attorney's fees against you. So, because that's what the rule says, Rule 47D says, the award of the arbitrators may include an award of fees if all parties have requested such an award. So, if you're in-house, be careful if you're a lawyer, because the other side asked for fees, we're going to ask for it too. Say, look at the rules. Are we under the commercial rules? So that knee-jerk reaction many parties have to simply ask for it, even though the agreement says we can't get it, let's just ask for it too. Or you don't ask for it in a pleading, but instead you're at the hearing and you put on evidence of fees because you think, well, I just want to, cover the record. You're asking for fees and you're giving the panel the power to grant them. I've seen this as an advocate. I've seen this as an arbitrator. And you don't want that to happen to you. Now, I told you that we'd learn tips on how to think arbitration is good. I hope you're at least warming up to that idea, how to streamline it, how to make it confidential, how to protect your mojo. But listen to Gordon Gekko in my other favorite arbitration movie, Arb Street. I think he puts the point across quite well.
The point is, ladies and gentlemen, that
arbitration,
for lack of a better word, is good.
arbitration,
Is right.
arbitration,
Works.
arbitration,
Clarifies, cuts through, and captures the essence of the evolutionary spirit.
I hope you have enjoyed our visit as much as I have. Thank you.